Hi, I'm Anthony Diosdi. I'm a tax attorney in San Francisco with over 20 years experience in international and domestic tax planning and tax litigation. You can find me at sftaxcounsel.com. And today we're going to be talking about the exit tax and the tax consequences of the exit tax, how to go ahead and expatriate from the US, and everything that's involved with it. Before we get going, though, I want to go ahead and make one disclaimer that this is not meant to be tax advice or legal advice that you can rely upon. If you need advice regarding expatriating from the United States from a tax point of view and from an immigration point of view, you should definitely consult with a qualified attorney. Okay, so that said, how does the exit tax work? So, what people understand is that when you're a US citizen or a US resident, you're taxed on your worldwide income. When you are not a US resident, then you're only taxed on your US source income. So, because of this discrepancy and because the US tax rates are so high, there's quite a few people in the United States who would like to leave the United States for tax reasons, expatriate to another country. Um, Quite a few people have been doing it over the years, and as time goes on, or at least over the past few years, the amount of people expatriating or leaving the United States has been increasing steadily. So, what is it? How does this process operate? Well, to be subject to the so-called exit tax or the expatriation tax, it only impacts either U.S. citizens or a U.S. tax resident. Who is a U.S. tax resident? A U.S. tax resident is someone who's been issued a green card by the immigration authorities. It does not impact somebody who is in the U.S. and they become a U.S. tax resident because of the so-called substantial presence test. And what the substantial presence test is, how it operates, is if you've been in the United States more than 183 days in a single year, um, and it also takes in consideration the previous 2 years, which is not that important for purposes of our discussion, then you could be a U.S. resident for purposes of this substantial presence test. Well, in any event, the exit tax does not apply to those individuals. It only applies to U.S. citizens leaving the United States, and also it applies to green card holders. Now, with green card holders, there's one other wrinkle in that it only applies to long-term green card holders, long-term residents of the US. What is a long-term resident of the US? That is somebody who's been in the United States more than 8 of the last 15 years. So if you have a green card and you've been in the United States more than 8 of the past 15 years, then you could be potentially subject to the exit tax when you are leaving the United States, or you're basically moving your residence out of the United States to another country. Now, there is an exception to that rule, and the exception to that rule is, let's just say one of the years you claim a treaty position on your tax return. What is a treaty position? A treaty position is, let's just say you have a green card, but let's just say you move to Germany for a year for your job, and you spend the majority of that year in Germany. You could take a position on your tax return if you're a green card holder that you have a closer connection, say, with Germany, and although you have a green card, you are not a US resident for tax purposes. By taking that position, you stop the clock, so to speak. You stop that 8-year clock. Now, on the other hand, if you take a treaty position after you've been in the United States with a green card more than 8 years, then that counts as an automatic expatriation. It's kind of a double-edged sword. It could stop the 8-year clock from running. Sometimes what people tend to do is they tend to go ahead and they look at previous years and they amend tax returns to stop that 8-year clock from running. And that is sometimes a tax planning tool that certain people utilize so they don't hit that 8-year rule. So now, let's just say you have a US citizen or a long-term green card holder, and now they're leaving the United States. They're going to another country. They want to break ties with the US. They no longer want to be a US citizen, or they no longer want to be a green card holder. Well, what happens? What is the tax that they could be assessed? Well, the tax that they could be assessed depends really on their net worth. So if you have a long-term green card holder or US citizen that is leaving the United States and their net value is over 2 million, or their tax burden over the past 5 years has been at least 206,000 on the average, then they're what's called a covered expatriate. And that term covered expatriate, that is when you can be subject to the exit tax. All right. So now let's just say you have somebody who is, their net worth is either $2 million, or in 2025 anyway, because this amount is subject to inflation, at least $206,000 over the past 5 years on the average of a tax liability, and now they are a covered expatriate. Well, what happens next? Well, what happens next is that according to the Internal Revenue Code, there's a treatment as if they sold their worldwide assets the day before they left the United States. So let's just say the day before they left the United States, there's a hypothetical sale which the Internal Revenue Code imposes on this individual's worldwide assets, and it acts as if this individual sold all their assets. And on top of it, too, it excludes certain provisions in the Internal Revenue Code that goes ahead and kind of offsets sale. Let's just say, for example, Internal Revenue Code section 121 excludes $250,000 of gain for a sale of a primary residence, or $500,000 for a couple from a sale of primary residence. That exclusion does not apply for purposes of the exit tax. So you have a number of exclusions that you'd save taxes on here in the US if you sold your assets. That doesn't apply if you are calculating the exit tax. The exit tax itself, it allows for 2025 an exclusion of $890,000. All right. So your first $890,000, that's not subject to the exit tax. If through planning prior to you exiting the United States, you can keep that gain under $890,000, that's beneficial because you may not be subject to the exit tax. All right. The exit tax itself is computed on a form 8854. So the year that, let's just say you're considering leaving the United States, you're subject to the exit tax, the computation itself is done on form 8854. That is attached to your last year's tax return here in the United States. That last year's tax return is, you're going to file a form 1040 and you're going to file a form 1040 NR, and you're going to attach to that form that your U.S. income tax return, that form 8854. That form 8854 will compute your exit tax if you have any, and you're going to go ahead and compute that exit tax the year after you expatriated, because the way it works is that the computation for purposes of the exit tax takes place the following year for tax purposes. So if you expatriate this year in 2025, you file the form 8854 with the IRS along with the form 1040 NR by the due date, which would be April 15th of 2026, unless you have an extension. If you file that form 8854 late, or it's prepared incorrectly, the IRS can automatically assess against you a $10,000 penalty, plus additional penalties if you went ahead and you misvalue the assets that's on that form 8854, or there's additional penalties if that form itself is not prepared correctly. So you definitely want to make sure that if you're exiting the United States, you are seeking out a qualified tax attorney to advise you for planning purposes how to minimize your exit tax, but also you are seeking a qualified professional who will prepare that form 8854 correctly. Now, there's a couple important things to know about when you're actually going ahead and taking consideration the computation of the exit tax. All right. The exit tax itself it's computed what's called a mark-to-market basis, right? And that means that each and every particular asset that the individual is expatriating from the US is computed for purposes of the determination of the exit tax. Now, there's a couple assets that's a little confusing to some. And one of those assets would be, let's just say somebody has stock options. So let's just say you have an individual who works for Amazon. And let's just say that individual has options. That individual leaves the United States, and let's just say the individual works for Amazon in Italy. For purposes of computing your Form 8854 and purposes of determining the exit tax, it's not that simple because what you're going to have to do is make an allocation between where that individual works. So if that individual worked so many years in the US and now will work for so many periods of time in Italy, or another country, you're going to have to make an allocation between the United States and that other country for purposes of determining the tax consequences of the disposition of those shares. So what will happen is not only do you have to go ahead and file a U.S. tax return the year that they left, you're probably going to have to file U.S. tax returns in the future as they go ahead and exercise their stock options. Another really confusing area is when somebody has a 401k or an IRA. Now, if you have a 401k or IRA, it's brought into the computation of your exit tax. Now, what you can do is if you have a 401k, you can make an election to basically defer the tax consequences of the liquidation of that 401k into a future date. Now, you have to do it within 30 days of leaving the United States. It's got to be done timely, and you got to notify your plan administrator of doing it, but you can at least defer that tax consequence for a later date. The downside to it is that when you do go ahead and you do pull that money out of that 401k, you're going to wind up paying a 30% withholding tax. Now, there are treaties out there that allow for a lower rate. Let's just say you have someone that goes to the UK, right? And we have a treaty with the United States and UK that allows for a significant reduction in the US or elimination of the US taxes on a distribution from a 401k. You're not going to be able to take that treaty position if you go ahead and you defer the tax consequences of that 401k when you leave the United States. All right. Now, what is interesting to know is let's just say you have someone that's leaving the US and they're not subject to the exit tax. Let's just say they're not a covered expatriate because let's just say they're below those thresholds. There are some tax planning opportunities that will allow that individual to go ahead and use a treaty from another country to either reduce or eliminate the U.S. tax consequences associated with pulling money out from a U.S. 401k or even an IRA. But that individual has to have already left the United States. And once they left the United States, they re-domiciled in another country. There might be some interesting tax planning options available that not only eliminates the U.S. tax consequences associated with pulling the money out of a U.S. retirement account, but also eliminates the early withdrawal penalties as well. Getting back to the expatriation, you can do planning only with a 401k and defer the tax consequences. This is not available to somebody who has an IRA. An IRA itself will wind up being taxed if you're a covered expatriate on the date that you wind up leaving the US. And also if you wind up working for a government institution. Let's just say you're employed by a university. Let's just say you're employed by Cornell University. And let's just say they had a government retirement plan, which mimicked that of a 401k plan. It doesn't, unfortunately, the way the Internal Revenue Code works for purposes of the exit tax, that does not allow you, if you're expatriating from the US and if you have a plan, I guess it's under Code Section 457, you can't go ahead and defer the tax consequences of that. All right. In a future discussion, we'll talk about planning options for people that are leaving the US and they have retirement accounts. So it's actually a very interesting area. All right. So now let's just say you understand the tax consequences. You've done your planning. Now you're ready to go ahead and expatriate. Well, there are some other things you have to go ahead and do, and this is not just in the realm of tax. This is a kind of an area of immigration. When let's just say there's two different ways of thinking about this. So if you are a green card holder, right, you're a long-term green card holder, and you're leaving the U.S. There is no such thing as an informal way of getting rid of your green card. You actually have to go ahead and you have to terminate your green card. How do you do that? So you left the US, you have to complete what's called a Form I-407. And you have to return that green card to the United States. It's very important. It can be done in one of two ways. You can either mail it back to the government along with that I-407. Make sure you have the date on that or the proof of mailing. If you have an attorney, make sure that the attorney goes ahead and sends that back to the immigration authorities timely. Any kind of documentation that was provided to you by immigration, you return that to the government as well. Or after you leave the US, you can just go ahead and visit a US embassy and return your green card to that US embassy. You can't just go ahead and throw the green card over the fence there at the embassy. You actually have to walk into that embassy, turn in your green card, complete that I-407 and make sure that's done properly. And that's the way you terminate your residency if you're a green card holder. If you do not go ahead and return that green card, even if you leave the US, if you have that green card, it doesn't matter how long you're outside the US, you are still going to remain a US resident for immigration purposes and for tax purposes. Remember, there is no such thing as an informal termination of a green card. If you didn't go ahead and terminate that green card properly, even if the expiration date on that green card has expired, you're still considered a US resident for purposes of the green card. All right. So very important to go ahead and terminate that green card. Now, if you're a US citizen, it's different. If you're a US citizen and you want to go ahead and renounce your citizenship, how do you do that? Well, you go and you make an appointment at an embassy outside the US. It's not free as well. So you have to go ahead and make that appointment with an embassy outside the US. Now, sometimes it's not so easy. A lot of times embassies don't want to go through the process of having an interview because what you have to do is have to make an appointment to meet with the proper staff at a US embassy. They got to interview you. You got to give up your passport. You got to fill out a number of documents and you got to do an interview. And it's not free. You also have to pay $2,350, I believe. You have to have that check made payable to the U.S. Embassy. You've got to fill out a number of documents. It's become much more complicated over the years. The government wants to know where you're working, who you've been working with over the past few years. So that the paperwork has to be done properly, and you have to be very careful how that's completed. Then you have your interview. And then approximately 30 days after the interview, you are notified by the US government whether or not they'll accept your request to terminate your citizenship in the United States. And it's not automatic. If it's declined, then you can actually go ahead and sue in the district court to sue over it. So it's a very serious matter. I mean, if giving up your citizenship is very serious, but if you're going to do it, there's a lot of paperwork that has to be done. There's a fee that has to be paid, and then on top of it, too, you're subject to the exit tax. You have to go ahead and file the same tax returns, the 1040, the 1040 NR, 80 to 54, everything we just spoke about in regards to long-term green card holders. That also applies to U.S. citizens as well. So I hope that you all found this to be insightful. If you have any questions regarding exiting the United States or expatriating from the United States, planning for the exit tax, give me a call. But I do want to say one last thing before I go ahead and sign off here. About a month ago, the IRS just enacted new regulations on a so-called gift tax. So a lot of people are doing in the past is that they were saying, okay, look, I'm going to expatriate from the US. So I'm just going to go ahead and gift all my assets to my spouse or to family members and so forth in order to avoid the exit tax. So the IRS recently enacted regulations that goes ahead and imposes a gift or an inheritance tax on an individual who gifts away their assets to avoid the exit tax, and that gift or inheritance tax actually falls upon the U.S. Recipient. So that's something to keep in mind as well if you're considering expatriating from the U.S. Seek a qualified tax professional. If you're considering expatriating, plan early and make sure that you retain somebody who has a significant experience in this area of law. Thank you very much. Have a good day.